Hello, everyone. Welcome to our invigorating seminar or webinar on the new budget 2026. It's an interesting budget this time because we are at the cusp of the end line for the Income Tax Act 1961 and the start for the new Income Tax Act 2025. Having said this, our finance minister presented this union budget against the backdrop of a lot of economic uncertainty, geopolitical issues, and fragmentation, and there was a lot of expectation as to what will come out in this budget. Of course, this was also at the back of the FTA signed with EU, and now we've also seen the agreement reached with Trump. So it seems that things seem to be on the track. The budget also shows that we are at a robust 7% growth rate. And the finance minister has anchored this budget based on, three duties of accelerating economic growth, fulfilling aspirations, and building capacity, and ensuring development to bridge the rural-urban divide. How much of that really translates, we'll get to know, as the year goes by. But at least, the intention of the government seems to be to focus on capital expenditure and make India, self-reliant. There has been a paradigm shift to the Income Tax Act 2025, and that's what this budget webinar is going to focus on the tax changes and the impact on foreign investors, international business community, and so on and so forth. The shift has been at the backdrop of simplifying the law, because the feedback has been given that the 1961 Income Tax Act has overlived its utility, and now it needs to be simplified. The language needs to be simplified, and it needs to be readable. Having said this, even before it's coming into effect from 1st of April, we have already seen a slew of changes being made to the Income Tax Act 2025. Probably the expectation is that from a policy perspective, if we can keep the changes to the bare minimum, that would be good. But I guess some things are not really going to change. We've also seen quite a few changes to remove uncertainty where matters are pending before courts. And that's something that's something that really needs to be thought about, because do we really need to give investors certainty here, even if those changes are probably bringing certainty in certain procedural matters, but do they really go to the core of hitting certain vested and substantive rights which taxpayers already have? That's another thing that we will be discussing in this webinar. So I'm just going to stop here, and I'm going to just hand this over to our founder, Mr. Nishith Desai. And Nishith bhai, will be great to hear your thoughts of on what you expected from this budget, and what you think this budget is going to bring about for our country as well as for investors looking at coming into India.
Yeah, I think thank you so much, Parul, for initial comments. What I thought, I'll just tell you my mind as to what I see as a constructive dissatisfaction, not as a criticism so much, but how can we move to the next level. And some of you must have read our budget alert, in which I talked about budget miss. There are few things that I feel. On the one hand, let me say the good side of the budget is there been an attempt to clear up a lot of micro level issues. But I think we have to now come more micro level. Micro level issues improve efficiency and things like that. But I think it is important to be effective. And in the process, big thinking is very important today. And that's what I mentioned in the budget alert, that, we have to come out from operational issues to the strategic issues now. And how do we position on a global basis? Okay. So most of the changes are just simplifying tax procedures, improving ease of doing business, digitizing compliances. They are very important one, no doubt about it. But at the same time, we have to see that, what are the next changes that we need to go for an exponential, growth of the country. It's so far we have been more on, I would say incremental in many ways. Okay. And that is one thing. But now we have to think exponential. We need to think out of box. We need to do moonshot thinking, put India on the global map and on the moon, I would say, and which is not impossible. We have to start coming out of our internal fear that if you do this or this would happen, this would happen. Excessive fear leads to excessive analysis. And excessive analysis, I would say analysis is good, but an excessive analysis leads to paralysis. I think that is what we do not want to see. We are doing well, we are going all right, but I believe that we have an opportunity and potential to go to the top of the world. Okay. And I think we have to believe that we can be, so we should set benchmarks for other countries. We should set what you call become the role model for other countries, right? And in that respect, I feel that some of the changes which could have been more easily brought in this time would have been, much more, I was thinking, exciting. So while this is good, but I think we could become great by doing some of the things, that I thought. Few thoughts that I have, and I would have hoped that they would have been allowed or talked about what you call IDRs. This idea is not something new. In 2004, companies law was changed, rules were changed, and SEBI regulations came up, and at the same time, tax things came up. But I think the way in which the whole scheme was done really resulted in negative, result. So Standard Charter was the one case that happened for this. IDRs are basically reverse of ADRs and GDRs. So foreign companies can list on Indian market. If we do that, I believe that our market will bump up. It will get a lot of visibility on a global basis. And number three, that foreign companies' traction for India would increase. The background to this whole thing, IDR, is that today, if you incorporate a company in US and tomorrow you want to list it on the Indian market, then you have to reincorporate the company in India. And that results in significant taxation on the side of the US because it is dim disposal of the shares of the US company by the US shareholders or otherwise. Now, that has stopped a lot of companies coming. I myself personally wrote 10 or 15 companies with at least $2 to $3 billion kind of valuations. So we are talking about $20 to $30 billion at one corner of the whole professional circle, right? And so like that, many other people would have the same thing. So if instead of reincorporating India, if allows foreign companies to directly list on India, depth of Indian market will improve, exposure for Indians will be better. Indians can invest in India and participate in the growth of a foreign company. So we have to start winning the world now. And so IDR is an important part of the next reform that we need to bring in. And idea has already been accepted. There's low hanging fruit. It just we need to implement the whole scheme in a much better, rationally sound manner. And that is what I was thinking. First thought that I had was. Second point is that crypto. Now, at one point of time, crypto was considered to be speculative asset and gambling kind of thing. But today, the world is embracing crypto. And Industrial Revolution 4, okay, the next generation of technology development will have integrated role of crypto because crypto is going to play a major role. And again, it would exist side by side, but I think crypto is being accepted more and more countries. More countries have now taken over. So we should not be left behind when others are building reserves, uh, including countries are building reserves. Deutsche Bank also said there were a certain percentage as a reserve. A lot of things are happening, crypto derivatives, and we are completely out of that cycle. And in the process, a lot of innovators, a lot of miners, a lot of other people have gone outside in Dubai and other places, and we are losing the game. So it should not happen that at a later point of time we feel, oh, we did not fully consider this. My recommendation has been to set up crypto and digital asset kind of regulator should be appointed, what you call crypto promote, promotion and regulatory agency, or I like IRDA, which is regulator as well as development agency, and so I think it is very important that we don't miss out on crypto. Let us not take it lightly. We are losing every day significant traction on that. India is one of the largest adopter of crypto. So I would say, but I think we need to change the whole ecosystem on that and facilitate legitimate acquisition of crypto. And all that you need to do is to contain the bad actors. And crypto, obviously, every thing will have upside and low side, and we have to contain the lower side. And that is the role of regulator. But you cannot control the development. And blockchain and other things will not exist unless you have the crypto part of it. So I would not go too much detail into this whole thing, but this is one of the other things that we can perhaps consider. And all that we need to do have robust KYC norms, AML norms, and cybersecurity standards and stuff. They are all possible today. Other countries have done it. Why can't we do it? Right? So that is the thing. And third point, which I've been talking since 1983, about which I wrote in my book, is freeing the rupee. I think the time has come now to free the rupee up, make it convertible. We should move towards full convertibility. As you know, the history of exchange controls when goes back to the war days in Second World War, and then we had this 47 exchange controls, and then 1973 we had exchange controls, and very tight exchange controls. The result was that we thought we'll lock in period people who come to invest in India, but we got locked out. So foreign investors did not come, and rupee was very badly controlled. So a lot of black money happened, etc. I would not go into details, but at the same time, when it came to 1980. 1993, 91, when the policy got liberalized, we went towards trade account convertibility, and later we went to current account convertibility. And it was expected that new Foreign Exchange Management Act compared to former Foreign Exchange Control Act, right? Control was replaced by word management. But today we are still back into the control regime. And I think there are too many micro level issues and stuff like that. I think time has come now to just move from current account convertibility of 1997 or 98 to now full convertibility. We'll come out as a very strong nation. There is a fear of unknown. Or if you do this, oh, all foreign nations go out. But today, Indian economy, Indians themselves want to invest more in India. Okay. And similarly, a lot of foreign people would want to invest in India. So my expectation was that we'll also begin to have some move towards freeing up the rupee, and we should be standing side by side. China is talking about being a reserve currency of the world, right? And US is also talking about losing the dominance at times, and they want to be stronger one. So India should not lose out in the game. So crypto, freeing the rupee, those kind of things are really big thinking, which we need to. And we are still talking about in the tax laws more on incentive and other kind of stuff. I think we need to create institutions and which will systematically, set the process for being on the global basis of positioning. And I would not go again into detail because we have lesser time today. Some point in time we can discuss, but that is another thing that we need to do. Second and last point I would make is I think we need really a reasonable amount of certainty in tax laws, in some other laws as well. Now, of course, we would be considered biased because the tiger ruling all of you heard of that. We don't know all of that, so we can't talk much about it. But at least the genie is out of the bag. And I think it last 30, 40 years, jurisprudence has been completely upset. So people's predictability has gone off, and that is causing a lot of problems. Although people have not spoken much about it, but globally this is what is being discussed. We should try to see that how do we avoid at the time when we draft regulations. Okay, there has to be um, enough discussion. Law commission should be involved. Many other issues are there to draft a law that is stable, right? Lord Macaulay drafted laws in the 1860s and 72 and all the thing. Today they are still valid in many ways. Okay, Indian Contracts Act, electronic commerce is still possible under the same law. So I think it is important that we have more well-considered laws which are stable. Now we need to move to substantial changes from what you call the procedural changes. I think on procedural changes, a lot of changes. Some of them have been good, no doubt about it, but many have also caused a lot of problem. And this retrospective and retroactive laws that are happening, it is creating a situation where the past is uncertain. So far as we have seen is people say future is uncertain, but here we are making past uncertain. I think these things do not augur well on a global basis, and I think these are few of the constructive suggestions I would make. Not taking away the credit for the good work that is done, but at the same time, it's a constructive dissatisfaction, I say, and we have a lot to do. There are many other things, but today is not the time for discussion. Um, I think this is what my initial editorial comment would be. And Parul, maybe you can now take it forward at the micro level, all the provisions that have changed, and it would be very helpful for everybody to know about technical issues as well. And wish you all the best. And I sit back and relax and listen to you all and have interaction. So have a good evening. Thank you so much, everybody.
Thank you so much, Nishith Bhai. We'll quickly jump into the budgetary proposals, and we'll start with the change which is going to impact quite a few M&A transactions, which is on buyback taxation. Now, of course, earlier initially buybacks used to be taxed as capital gain income, and there used to be situations where foreign entities that were investing through Mauritius or Singapore used to repatriate cash from Indian entities by the Indian entity doing a buyback. And this was supposedly, at the behest of the foreign entity and primarily a cash repatriation strategy so that they could take an exemption under the various tax treaties. In order to plug this loophole, the government introduced what was called a buyback distribution tax. It wasn't really like a dividend tax, but it worked almost like that. It had its own set of issues, which we will not get into because subsequently, in 2024, the buyback distribution tax was removed, and the capital gains tax came back along with a dividend taxation mechanism as well. This itself created some issues because the amount which was paid out to the shareholder was subject to tax as dividend. And this meant that there was tax even on the capital that was repaid, with the capital loss being available to the shareholder for carrying forward. Now the government is proposing to just remove this anomaly and just to bring back a plain vanilla capital gains tax for buybacks taking place. But is it really as simple as that? Ipsita, maybe you can just talk about what are the issues with the proposal that have been introduced.
Yeah, sure. Thank you, Parul. Thank you for setting that background. I think, like Parul mentioned, the buyback tax was removed and the new regime was introduced in the Finance Act 2024. What the current bill proposes to do is also to roll back the 2024 framework and restore the treatment of buyback proceeds as capital gains in the hands of shareholders. Shareholders will be entitled to deduct the cost of acquisition in accordance with the general capital gains computation provisions, which effectively should eliminate the issue on taxation of capital Parul just mentioned, and also the timing mismatch, because timing mismatch prevalent under the 2024 framework, because The loss set off was contingent on availability of gains in future and whether that particular shareholder has any further investments in India or not. So at the outset, the proposal is good, but the proposal also kind of distinguishes between a non-promoter shareholder and a promoter shareholder, and it seeks to introduce an additional layer of tax on capital gains arising to shareholders which will qualify as a promoter. The rate of this additional tax will depend upon the nature of the promoter, that is, whether the promoter is a domestic company or it's a person other than a domestic company. As per the memorandum which has been issued, the reason for this differential treatment seems to be the fact that promoters are in a distinct position to influence the corporate decision making, specifically the power to influence whether a buyback should be undertaken or a dividend payment should be made by the Indian company to its shareholders. Like we discussed, at least for non-promoter shareholders and small shareholders, this is a welcome move because it goes back to the most initial framework for taxation of capital gains, which is characterized as capital gains itself. However, there are 3-4 issues with this framework which is proposed specifically in the context of promoter shareholders. Firstly, let's talk about the impact on tax rates. If we were to just compare the tax rates on buyback in case of long-term capital gains arising pursuant to this amendment, for a domestic company which qualifies as a promoter, the tax rate could go approximately to 25%, and for foreign companies, it can go up to 33%. For non-resident individuals, the rate goes even further higher. And in case of unlisted shares, the tax impact is further higher, with foreign companies probably getting taxed on buyback uh, at a rate approximately equal to 49% in case the capital gains are short-term in nature. So the tax impact is maybe really high. So buyback transactions will have to be seen in that context. Coming to the key issue on who is a promoter. The bill proposes 2 definitions. Firstly, the first part of the definition relies on the meaning of Companies Act and SEBI regulations for listed companies to determine who is a promoter. Both the Companies Act definition and SEBI regulations rely on determine the promoter status by reference to a degree of control or influence which is exercised on the company. This determination in itself can be very fact specific, and it's a very contextual inquiry. So now if a company is planning to do a buyback, this factual analysis may have to be undertaken to see who qualifies as a promoter and who is not a promoter. Second part of the definition which has been proposed, the bill is proposing that any person who is holding either directly or indirectly more than 10% shares in a company will qualify as a promoter. Now, 10%, firstly, there is no explanation on how this 10% threshold has been selected. There is no explanation to this. 10% is not a very high kind of threshold that a shareholder holding 10% of the company can influence, whether it can influence any corporate decision, so to say. Secondly, how do you calculate the 10% number? If there are convertible securities on the cap table, if there's a shareholder who's holding redeemable preference shares, do you take into account these shareholdings to determine the 10%? That is not clear. Thirdly, like I said, the 10% shareholding the bill proposes to see on a direct and an indirect basis. Now, why a indirect test is needed for determination of who is a promoter is not very clear, because if someone is considered to be a promoter because of ownership attributed to that person on a look-through basis, it's unclear how this additional tax may be applicable to that person. Um, Lastly, this because because of this, the way they have put in this additional tax, there can also be some impact on pass-through structures like for AIFs or business trusts who hold the equity capital of companies directly, because these entities are taxable on a look-through basis, on a pass-through basis. It's unclear if there's a buyback of the shares held by these entities, how does the company determine the taxation? Because does the company has to see the shareholders of the unit holders of these entities on a look-through basis and then determine the 10%? So there may be some complications because of this additional tax that has been levied. But on an overall basis, at least for small shareholders, for shareholders holding less than 10%, the regime has moved to a simple capital gains characterization regime.
Thanks, Ipsita, for for the detailed analysis. And of course, it sounds a little bit more complicated than what it is. There's also this thought of, can one now actually take benefit under the income tax treaty? Because if it is capital gain income, then can you really take benefit if the shares were acquired prior to 2017? But of course, one will also have to bear the Tiger ruling in mind. But that's another aspect that needs to be thought of. Moving ahead, we see that in this budget, there have been a couple of changes in industry, or rather a couple of exemptions that have been introduced, which are more related to, to industry, the semiconductor industry, as well as the, the cloud computing service industry. Now, this whole issue is linked to establishment of a P in India. Now, India had introduced the significant economic presence concept along with the BEPS action plan, where the threshold is very low in order to establish an SEP, but most of the companies come from treaty jurisdictions, so the concept of P would apply to them. We've seen of late, we saw in the Hyatt ruling, we've seen also in the, the old JP ruling as well of the Supreme Court, that judiciary has been consistently looking at substance over form. They're not really following the actual technical rules of the game, and really seeing how the control of where the control of the business really lies. Given this uncertainty on how the judiciary is and the government is looking at PE issues, there are certain business models in the semiconductor industry as well as the cloud computing industry, which could potentially give rise to litigation around the PE aspect. And technically, they might not really establish a P in India, but there is enough uncertainty caused as to how the tax department is going to really view certain of these models. So given that, and also given that, this budget's framework is to really push the manufacturing sector, make India the global hub for the semiconductor industry, which is, we saw the, the different the different steps the government has really taken in order to, introduce India as a semiconductor hub as well as a contract manufacturing hub for electronics. This is an exemption which has been provided specifically for these two industries in order to take away any aspect of litigation from a PE perspective. At least that was what the industry ask was. But is the language really so clear? Does it really remove the litigation? Was it really required? Are there any other issues that actually come up? Are the conditions which have been imposed, are those conditions something, which can really be followed? I'll turn it over to Joe. Joe, maybe you can give your perspective on how the semiconductor industry is really working and whether this is really something that they were really asking for.
Thanks, Parul. So absolutely, the government has introduced an exemption for foreign companies that are engaged in supplying capital goods for electronics manufacturing in India. But given, news articles and the current geopolitical climate, it's widely understood that this is aimed at attracting semiconductor manufacturing in India, to build that ecosystem, to build that manufacturing base. And to that extent, that's definitely something that is important from both an economic perspective as well as a geopolitical and national security perspective, to have our own semiconductor manufacturing base. But the fact remains that at the end of the day, when these foreign companies make use of this exemption will fall to be applied by assessing officers at the ground level. And it isn't a given that those assessing officers will always be aware of the policy behind these changes. more often than not, they will be seeking to apply the law based on how it's written, which is why it becomes important to look at these exemptions and see how they're drafted to see whether it's actually trying to achieve what we think is the policy intent. So like you mentioned, the concern is that in the semiconductor industry, semiconductors are manufactured using lithography machines, which are an extremely specialized form of machinery. And for various commercial reasons, sometimes the foreign parent company wants to hold on to title to this machinery when it is sent to India for manufacturing in India. And the concern is that the presence of this machinery in India could potentially create a taxable presence in India, resulting in the global income of the foreign parent being subject to tax in India. Now, setting aside whether legally there is any merit to this concern, the fact remains that there is definitely a litigation risk because Indian tax authorities have been known to fall slightly more on the aggressive side of the spectrum. So that litigation risk does exist, even if ultimately, the foreign companies prevail. So to that extent, it does seem like the government is trying to assuage that concern. Whether this exemption actually does that. So the exemption is basically for income that arises to a foreign company on account of providing capital equipment to an Indian company, where that Indian company is engaged in manufacturing electronic goods. There is a requirement that the machinery is continued to be owned by the foreign parent, although it can be under the control of the Indian manufacturing entity. The equipment must be in a customs bonded area. The end product manufactured must be sold back to the foreign company. And this exemption is available for a period of 5 years. The potential issue rather arises in that the fact that the exemption is limited to income arising on account of providing capital goods. So there is definitely a reading of this provision that limits it only to income on account of providing. And when we look at the fact that ownership is required to vest with the foreign company, is it possible that income here is referring to lease rental income that the foreign company earns because it's leased or rented this equipment to the Indian subsidiary? There is language in the finance memorandum as well as in other provisions of the finance bill that gives some credence to this argument. So what will really be critical is understanding from the government what is actually the intent behind this exemption. Is it simply to provide an exemption on rental income, in which case the benefit of this exemption remains to be seen, or is it more to ensure that the global income of the foreign company is not taxed in India by virtue of it being deemed to have a PE in India? And that is that exemption is far more beneficial, and that seems to be what the industry wanted.
To add one point, I think the drafting point which Joe was mentioning, one really interesting, if we see the two exemptions that have been introduced, one for semiconductor industry and the other one for the data center industry, there's a very interesting distinction in the language that they have used. For the semiconductor industry, where the exemption has been introduced, the language that is used is income arising on account of providing capital goods is considered to be exempt. In contrast, for the data centers exemption, the language that is used is income accruing or arising or in India or deemed to accrue or arise in India. I think considering the intention, or at least what the ask was from the industry players, the ask was to exempt any potential income which is attributed to a PE which may be constituted by these foreign entities. And in section 9, such type of income is deemed to accrue or arise in India. And that deemed to accrue or arise in India language itself is missing in the exemption that has been provided for a contract for the tool manufacturing which takes place in the semiconductor industry. So I think this is an intention of the legislature, but it can surely be a point of contention in future.
And also, I think even if you look at the way that the model works, the intention is not really to send the machinery to the contract manufacturer. The whole idea is not to really earn lease rentals on it. And they might just be sending the machinery, free of cost without any charges, uh, just to enable the contract manufacturer to use their machinery, use their processes in order to be able to, produce the electronics as per the desire of the foreign person. But like Joe mentioned, and like Ipsita is talking about, probably the language needs a little bit of change, because what happens at ground level is that the language is again misinterpreted, and then the case goes up the ladder at various levels, and then, like we're saying, there are retroactive amendments that take place. So definitely we don't want to be in that situation. The other interesting aspect is that while technically speaking, this does not really create a permanent establishment in India, because just by sending a machinery to India, which is under the control of the contract manufacturer, doesn't mean that there's a P in India. But nonetheless, by providing this exemption just for 5 years, it opens up a Pandora's box as to what happens after 5 years. I mean, definitely contract manufacturing contracts are not going to be there just for 5 years. And then again, we are going to be looking at the government extending this. And if it doesn't get extended, then again, litigation taking place. Moving on quickly, Ipsita, you spoke about the data centers and, how the language is different. Do you want to tell our audience about how the data center model really works and what the government is really trying to plug in by introducing the exemption for income earned by foreign cloud service providers?
Yes, sure. So before we go into the tax aspects, I think there was a very interesting fact that was noted in the economic survey which was tabled this year. The fact is that India hosts only 3% of the global data centers, even though India generates approximately 20% of the global data. This is a huge, huge number. And currently, even this essentially means that 95% of Indian data is also being stored outside India. So, what are data centers? At its core, data center is a very specialized facility which houses large computer servers, storage systems, and networking equipment. These servers are responsible for storing, processing, transmitting digital data on a continuous basis. Every time a user uses any cloud service, for example, any digital payment service, any service which we avail on a streaming platform, or any AI tool which is used by a user, the service providers, which are tech companies, rely on these data centers operating in the background to provide these services. Now, customers, and the way these these models work in a way that the customers have the ability to choose the geographical region in which their data is hosted or processed. So it may be a possibility that the customer is in India and the data is stored in a server, say in UK, or vice versa. These global service providers procure services from data center providers on a principal to principal basis for further selling their tech capabilities to their customers globally. And the data centers are basically hosting the data generated by customers or data generated by the tech providers on their platform. So, what is the underlying tax issue in this model? If we, like we were discussing some time back when we started discussing this topic, under Indian law, foreign companies are taxable on income which accrues or arises in India. And income is deemed to accrue or arise in India when a foreign company constitutes a permanent establishment in India. In this context, we have seen that in some cases, tax authorities have alleged that foreign companies providing digital or cloud-based services through data centers located in India constitute a permanent establishment in India, thereby subjecting a portion of their global income to tax in India. The exemption which is currently proposed in the bill seeks to put this controversy to rest. This exemption has been proposed for a period of 20 years, which goes a long way to show the government's commitment in promoting this sector in India. However, going back again to the drafting point that we were discussing, that the drafting again seems to be a little bit unclear, because the income which is given the exemption is income which is accruing or arising or deemed to accrue or arise by way of procuring data center services from specified data centers in India. As such, if we were to see directly, there is no income which would arise just by virtue of procuring data services from a specified data center. Probably the intention was to exempt income arising from services provided through procuring the services from these data centers. So it's a very fine nuance, but this language is not exactly covering at least what industry sought the exemption for. Having said this, there are also specific definitions which are given under the proposed bill. Long story short is that at least the government is likely to come out with a scheme which will notify who are these specified data centers, and only these specified data centers which are owned and operated by Indian only these specified data centers will be eligible to claim this exemption. There is another condition which is given under the bill, that all sales by the global service providers to users located in India are made through a reseller company located in India. While typically this is how the arrangement works, there can be some questioning on how do you determine whether the sales are being made to Indian users directly from this Indian reseller. Overall, this is a very welcome move, subject to the fact that the language could have been slightly better. In addition to this, in addition to the exemption on the income arising, deemed to accrue arise in India, but in the budget speech, the finance minister also introduced a safe harbor regime for data services availed from an Indian data service provider. Under the proposed safe harbor regime, the finance minister has proposed a margin of 15% for provision of data center services to global providers. This again is a welcome move. While this change will come through rules which will be notified in due course, this should definitely give certainty between the data center insofar as data center arrangements are concerned. Having said this, currently there is no safe harbor regime, at least on the reseller arrangement side. So some clarity on that side would also have been welcome.
Thank you. Thank you, Ipsita. We'll now quickly move on to, we have just 15 minutes to go. We'll quickly talk about some, administrative changes that have been brought about in the Income Tax Act, the old one as well as the new one. The first one is, we all know that there have been a lot of cases pending before the Supreme Court with respect to statutory period of limitation, where a lot of orders passed by the dispute resolution panel may be regarded as infructuous because the timeline is under challenge. There's a controversy around the timeline within which the order should have been passed, and whether the order should have been a draft order or a final order. We are aware of the controversy between JAO and FAO, the jurisdictional assessing officer, issuing notices, and that being held to be not that held to be not valid as compared to with respect to the faceless assessment scheme which has been brought into the act. And also we've seen the Pfizer case, where this whole issue of the order being passed 60 days prior to the due date, and how do you really read the 60 days. So what really has happened in this budget is that there have been a slew of changes where retroactively the government has changed the law to remove the controversy around many of these aspects. Of course, some of these aspects one can think about, for example, when we talk about the timeline issue and the Shell drilling case, which was at the Supreme Court, and the Supreme Court delivered a split verdict. Maybe some of these practically should makes it very difficult for the tax officer to really pass the order within the time frame. But by making all of these retroactive changes, though these are more with respect to the statutory period of limitation and the timeline, they do impact vested rights of taxpayers. And the question that really comes to one's mind is that, couldn't this have been thought of better at the time of drafting of the law as compared to waiting for so many years and trying to fix it now? So, Joe, do you want to just talk about what these controversies are very briefly, and we can also then see what can be done about this and what should have probably been done about this.
So the first litigation issue relates to whether the dispute resolution panel process, which is a special assessment process that's applicable to non-residents and taxpayers who have transactions that need to be transfer priced, whether that process falls within the overall limitation period for completion of an assessment. There was a lot of litigation both ways, and there was, like Parul alluded to, there was a Supreme Court ruling by a two-judge bench, which was split. So one judge believed that, yes, the DRP process is subsumed within the larger limitation process. The other judge felt that wasn't the case. What these amendments have done is that they've now clarified that the DRP process is its own standalone process and is not subject to the general limitation period on assessments. So effectively, now, there is a longer time limit that is available for completing the assessment in cases where the assessment involves a reference to the dispute resolution panel. The second significant change is the controversy surrounding the faceless assessment officer and the jurisdictional assessment officer. Basically, the question was who has jurisdiction to issue a notice to reopen an assessment. And there have been rulings from multiple high courts that have fallen on both sides of this dispute. And this too was pending before the Supreme Court. What the tax authorities have now, what the government has now said is that it is the jurisdictional assessing officer who has the authority and the jurisdiction to initiate a reopening of an assessment. And once that reopening is validated, the jurisdiction moves to the faceless assessment officer who will continue the assessment proceedings. A lot of taxpayers had argued that the jurisdictional officer does not have jurisdiction. So this ruling essentially vitiates that argument, this amendment rather. The next point is on the timeline within which a transfer pricing officer had to send his order to the assessing officer. So in assessments that involve the transfer pricing analysis, there is usually a reference to the transfer pricing officer who has 60 days to send, who must send his order back to the assessing officer at least 60 days before the assessment limitation period expires. So there was a big debate on whether the 60 days includes the day on which the limitation period ends or does not include that date. And the amendments proposed by the bill have basically said that that date is included, and they've hard-coded timelines into the old act as well as the new act. So again, this has gone against the taxpayer. So yeah, so Parul, these are the changes. And like you said, there are definitely questions that can be asked around whether these changes should be retrospective or not. I think the immediate question is what happens to the cases that were pending before the Supreme Court. I think, we've already seen an instance where the Supreme Court has remanded these issues back to the high courts where they were being litigated earlier. So that's definitely a possibility. There is also the possibility that the Supreme Court decides to hear the matters and factors in this new law. If the hearing is scheduled after the bill becomes effective, then this new law may be factored in. Of course, as you also said, the question then becomes, do we give retrospective effect to these amendments or not? Yes, they are procedural and they have been called clarificatory, but the fact remains, if they do affect the vested rights of the taxpayer, and in this case, that would be, the right to know, or rather the assumption that your assessment has ended. And so if the assessment is reopened, then is that taking away your vested right? And based on that, courts may either read these amendments as having prospective effect, or if they feel it is still purely procedural, may give retrospective effect to these amendments.
Right. And we also saw that, there's a circular that came out, just yesterday where the government has directed all AOs to seek adjournments in all the cases where these issues are pending. So clearly they're waiting for, the bill to become an act. Definitely, this is not the last that we've heard on all of these matters, and Supreme Court will have to decide. We saw that one bench of the Supreme Court remanded a batch of cases back to the High Court because probably this issue has not been heard, and the High Court will have to look into the issue of the retroactive applicability. So we'll see where that goes. Just moving on very quickly.
Sorry, Parul, just one more point to make here, right? I think it's important to highlight, right? Like, it's important to recognize that some of the issues here could have been addressed if the department simply had a smaller workload in terms of being able to finish an assessment on time. It's not necessary in every case that the transfer pricing officer has to wait till the last date to send his order to the assessment officer, or that the timelines prescribed for the dispute resolution process have to be exhausted in their entirety. So it's definitely possible to have achieved for the tax department to have worked within the framework of the law as it existed, if perhaps its resources were allocated in a more targeted fashion. So I think it's worth asking, whether it would have been more beneficial for the tax department to think about what cases it wants to litigate, choose the cases where it has a genuine chance of being upheld on appeal, and letting go of the cases where there is a high chance that the addition is reversed on appeal. That may have been another way to achieve the same outcome and work within the confines of the law without entering into this retrospective applicability business, which, as you said, does affect the ability of investors, taxpayers to believe that tax laws have certainty, to believe that tax laws are fair.
Right. And this is something which can then, it goes quite to the root of the biggest issue in India, which is judicial certainty and the timeline taken for resolving tax cases. But anyway, moving on, we are almost out of time here. There's a very important change which has been brought in with respect to, merging the penalty and the quantum proceedings. Now, we all know that penalty proceedings are initiated by the tax officer, but they're kept in abeyance till the time the final order on merits is not passed. And the tax officer gets 60 days, beyond that, for passing of the penalty order. By merging the two together, this is going to crunch while, the government is trying to show that, it's more of an efficient system. But in reality, what it does is that more likely than not, if the assessment order is going to be against the taxpayer, the penalty order is, of course, also going to be against the taxpayer. If you're talking about a 200% penalty levied on the tax amount, then in order to appeal against, such an order, there will again, have to be followed the entire process of prepayment of, the penalty, a percentage of the penalty, which is now being proposed to be reduced to 10% from 20% in order to make an appeal. But that amount will need to be paid upfront, so taxpayers are going to be out of pocket in order to appeal that. And the second issue that will arise is that the interest clock typically starts from the date of the order of the penalty. By delaying the penalty proceedings, the taxpayer did not have to pay interest, and especially, in situations where the penalty can go either way. By merging the two proceedings, the taxpayer might be litigating the penalty proceedings, but if they're finally held against him, the interest clock will start from the date of the passing of the combined order, and not really, he will not get the benefit of the deferral. So this is going to be, important from an M&A perspective as well, because indemnities will get renegotiated. The penalty order, there is some leeway which has been given where interest chargeability is concerned, for the DRP proceedings at the ITAT level and otherwise at the CIT officer level. So there is one appellate level of relief which has been given there. But irrespective of that, this is going to mean that indemnities are going to get renegotiated in M&A transactions, and this is going to have an impact going forward for any new assessments, that are going to be initiated. I think with this, these are the most important parts. I think Ipsita, if we can quickly talk about the changes which has been brought over for the MAT regime, which effectively results in the MAT regime being phased out. And we can talk a little bit about what is happening around the gift city, and then we can wrap up.
Yeah, sure. So for the MAT regime, I'll just make it really quick considering the time as well. For the MAT regime, what essentially has been proposed under this bill is that to make MAT the final tax. As some of you may be aware that the Indian government started on a path of systematically phasing out the various deductions and making corporate taxation simple. In this regard, a special concessional tax regime was introduced wherein a lower rate of 22% and a 15% corporate tax rate was introduced for manufacturing companies. For companies which opted for this concessional tax regime, the government provided that MAT will not apply to these companies. And for the transition from the normal regime to concessional regime, it was also clarified that these companies who will opt for the concessional regime, they cannot carry forward the MAT credits they had generated when they were in the normal regime. Now, this effectively kind of resulted in a roadblock because for companies who had very high MAT credits, they did not really uh, think that the concessional regime will be so beneficial for them as compared to giving up their MAT credits. Now, what has effectively been proposed is that if there's a company which is not opting for the concessional tax regime, the MAT that the company will pay is the final tax. The MAT rate has been reduced from 15% to 14%. If and when the company chooses to transition to the concessional tax regime, the MAT credit which is accumulated by the company till 31st March 2026 will be allowed to be set off as per the new provisions, which I will just discuss. And no fresh MAT credit will be generated in the hands of these companies. So effectively, whatever tax they pay in the MAT is the final tax. For companies which are opting for the concessional tax regime, what has been allowed as compared to the earlier position where these companies were not allowed to carry forward the MAT credit, they are now allowed to carry forward the MAT credit, which was accumulated till 31st March 2026, but the set off is capped to 25%. Like Parul said, this essentially indicates that the government wants to push or incentivize companies to adopt the concessional tax regime and gradually phase out the whole MAT framework. I think that's all on the MAT changes. Quickly covering the changes that have been implemented for the IFSC, the flagship project of the Indian government. I think since the time the government has introduced and operationalized the GIFT City and IFSC, there have been a slew of changes which have been proposed by the government, both and regulatory perspective, to boost the IFSC in India. Continuing with that intent, the government has proposed two changes in this bill also. Both the changes are quite important and should boost this IFSC region even further. The first change is that there is a tax holiday for units operating out of the IFSC. The tax holiday earlier was for a period of 10 years or 15 years, depending on whether you are a IFSC unit or you are a offshore banking unit. The government has now proposed to extend this tax holiday to a consecutive period of 20 years or 25 years, again, depending on whether you are an IFSC unit or a offshore banking unit. This is this move is going to give a lot of certainty to all the stakeholders who are looking to set up shop in IFSC. Taking an example and talking from a fund management perspective, because the regulations for fund management envisage that fund managers can use the same entity and keep launching different funds. This is in line with what the industry would expect, and it gives certainty for future period that this tax holiday is not going anywhere. The second change that has been introduced insofar as IFSC is concerned, that uh, it is more in relation to finance companies and finance units. Typically, there's a whole framework for setting up of treasury centers by these finance companies and finance units, wherein they can provide treasury services on behalf of a group entity. Uh, in the last budget, the government introduced a exclusion from dividend, from the definition of dividend, wherein certain loans and advances made between group entities, wherein one entity was a finance company set up in IFSC, and the parent is set up in a and the parent entity which is set up outside India was excluded from the definition of dividend. What essentially this amendment did was any loan or advance which a finance company is making to its parent company which is outside India or vice versa was not considered as dividend. However, there was a loophole because it was not really, it could also envisage a situation wherein an Indian entity is giving a loan or advance to the IFSC unit and this exclusion is getting applied. They have kind of plugged this in and they have specified that the other entity that is giving this loan should be in a place outside India. So therefore, this is more kind of a issue from a drafting perspective, which was there, which they have plugged. But again, considering that they have kept the change alive and they have not made any further amendments to this exclusion, so to say, it should provide certainty and should go a long way in boosting treasury center setup in IFSC. Parul, over to you for concluding remarks, I think.
Thank you. Thanks, Ipsita. Thanks, Joe, and thank you, Nishith Bhai. I think we've seen quite a bit of changes come in this budget. Even though the expectation was that with the new Income Tax Act 2025, the changes would be minimal. We'll have to wait and see how the retroactive changes pan out. And of course, as tax practitioners also get used to reading the new Income Tax Act 2025 along with 1961 Act. So everyone needs to be aware as to how the transition provisions are going to take place from 61 to 2025, and the old act will still continue to apply for for earlier assessment and certain provisions. So with that, I think Nishith Bhai, if you have anything to say, then
yeah, I think just 2 points here. One, question arises whether tax department would question every single tax resident certificate or not, also in cases of what has happened in the past. Second point is, I hope exemptions from residency would have been given to non-residents. Now, the period of 90 days is not allowing them to comfortably come to India and to do business, because they always have to keep 20, 30 days in reserve for sickness or otherwise. So they are able to spend 1 or 2 months. Beyond that, if 90 days are covered, then they are very much worried about filing of tax returns and other kind of stuff. So, so I think that's something that we need to really reconsider. Tax residency test itself should be eased up, including for gift city, for example. A lot of people want to come, they have to personally pay attention to the business. And I think we need to rethink about the whole thing. And I believe these are kind of things that we really... Third, one point comes to our mind of the cuff is that while we give tax incentives, that means there is no tax on the foreign subsidiaries of, say, particularly US companies, right? They're taxed on the worldwide income. So even if you give tax exemption in India, it doesn't absolve them of the tax liability in the US. So one needs to consider the effectiveness of the tax exemption. How do you grant tax exemption? What can you do? And things like that. So I think these are a few interesting issues that remain unanswered, and in the future, hope we see more clarity on the tax laws and more tax certainty. You already discussed enough. I don't need to talk too much, but with those comments, I think we can say au revoir or say goodbye for today, but hope to stay in touch with you all always. Today we couldn't take many questions because the time is up, but hopefully we'll have more chance to interact in the future. Thank you so much.
Thank you, everyone. Thank you so much. Thank you for joining us. Thank you.
Thank you.